All right, this is Carl Alfred reporting for thescannedretina.com, and this will be the third installment in our interview with Paul Nally, former judge and former police chief from White, Georgia. Now, where we left off was the citizen's arrest and the failure of the peace officers to take into custody the people that had been arrested. Now, the question begs to be asked, since they were arrested, are they still arrested?
Under the law, once an arrest is perfected, the individual stays under arrest until legally released from arrest. Now, legal release from arrest can occur if a committing magistrate finds insufficient probable cause to issue a warrant for arrest. It can also occur if two grand juries, well, actually, getting out of jail type of arrest can occur with a grand jury no bill, but that does not get the individual out from under the state's thumb, number one, and technically it does not release them from arrest. And the reason being is that under Georgia law, to be completely free from any arrest, any criminal prosecution, on a particular criminal charge, you have to have a second grand jury no bill. A nolle prosequi will not do it. And I'm having a senior moment. I just lost my train of thought.
That's probably because we're sitting here sipping on some wonderful iced tea that your wife made, and thank you very much.
Oh, I know. And the expiration of the statute of limitations. If you're not prosecuted, taken to trial within the statute of limitations, then the state can't touch you after that. Except,
It's always an all of a sudden.
you got this problem with the grand juries being charged in the state of Georgia as judges of the law. And if they find evidence of official obstruction of a criminal prosecution that takes a case out beyond the statute of limitations, they can nullify the statute of limitations and return an indictment with instructions to the judge that the statute of limitations had not expired because of governmental misconduct.
So, now that we have governmental misconduct in the form of Police Chief Michael J. Register failing to perform his duty.
He did not fail. He refused. There's a difference.
Refused. And the curious part about that is, not only did he refuse, he steadfastly refused to even look at the law that we were citing. And nobody at present is looking at the law that we're citing.
How long do you think it took for Register to come out there and do his little spiel?
Oh, not long.
Not long. Probably 2 minutes would be a stretch.
Pretty much. In
2 minutes, may I read to you a list of the state crimes that man committed?
Please do.
16841, robbery by intimidation.
Oh, how do you get robbery out of this?
Well,
putting you on the spot.
No, I'm not on the spot. That's a different topic. But let me read this and then I'll explain robbery.
Okay.
Violation of oath of office, threatening of witnesses in an official proceeding, influencing witnesses, hindering apprehension or punishment of criminals, aiding or permitting another to escape lawful custody or confinement, and extortion by a public official. Now let me get back to the robbery. You got to understand, When you talk about a Georgia criminal statute, each statute has elements, and you have to prove each of those elements. Well, here's the problem for him in the robbery. Property is defined in Georgia Code 16-1-3, subparagraph 13, as anything of value. Your intangible rights are things of value. Intangible rights include your right to arrest for crimes committed in your presence.
Okay.
Now, it also requires, the robbery charge requires the use of deadly force or intimidation.
Yeah, we got that going on.
We can prove the elements of the crime of robbery against the police chief. We have all the evidence we have, all the video is clear. He, not only that, but the federal charges against him are going to be the same criminal charges, which, by the way, the criminal charge pertaining to that robbery, the state charge of robbery, will be filed under 18 U.S.C. 373, which is ordering law enforcement officers to violate federal criminal statutes. You know, this poor guy is messed up. I mean, he's looking at least, between all these statutes, he's looking at 50 years.
Now.
Oh, but he's such a fine, upstanding citizen. He protects us.
No, I'm sorry. He does not protect us.
Well,
he
you're right.
protects the criminals.
He protects the criminals.
Just as Tracy Lawson does, just
right.
as the county commissioners do. We're in a bit of a quandary here, and we are affecting every lawful legal means at our disposal, and this is proving what we have witnessed on the national scale with Hillary Clinton, and they refused to prosecute her. The FBI refused to prosecute her.
Did you hear my commentary this morning, my observations from the rule of law about Hillary's problem?
I came on a little late.
Little late?
Yeah.
Well, I'll be real brief with that. Even though the FBI has recommended no prosecution and the Attorney General has agreed with them, Hillary's problems aren't over. And the reason they're not is because the final authority, even in the federal system, is a federal grand jury. Any federal grand jury in any district court in any state has not just the duty but the authority to demand by subpoena ducis tecum every FBI agent be brought out that had anything that touched that case to be brought into their court. I don't care if it's in Spokane, Washington, if it's in Hawaii or El Paso, Texas, and along with the evidence, and that grand jury go through and make their own determination. And if they file an indictment against Hillary Clinton, that indictment will be read in whatever district court they're in, and then that judge in that district court will have to order the clerk of the district court to transfer that indictment to New York, where the district court has jurisdiction over Hillary and her office, or her prior office.
Okay.
So they're not out of the woods. And plus, if they really know what they're doing, the grand jurors, they can also issue an indictment against the FBI director and the United States Attorney, Loretta Lynch, for obstructing a grand jury investigation.
Okay. Now, let's come full circle with this thought. Is it not incumbent upon those who see this travesty of justice to get their information in front of a federal grand jury?
Sure.
anywhere in the country?
You have a right, as a matter of fact, it's codified in 18 USC, here I'm having another senior moment, 18 USC 3000 and something, where the language of the federal statute makes it very plain to a United States attorney. If you have a criminal complaint to make, you can submit it to the United States attorney along with a written demand of presentation to the grand jury. He has no choice. He must present to the grand jury.
Okay. Hearing that, it is incumbent upon those of you who believe that crimes have been committed against the public by Hillary, and in this case actually by Obama himself, because he's involved in this by virtue of the communications allegedly occurring between those two. But that is a matter, again, for the grand jury. We believe that these things occurred, and based on that belief, we are entitled to put forth these presentments to the grand jury. Is that a wrong statement?
No, that's
Thank you.
correct.
So all it entails is get in touch with myself, get in touch with Mr. Nally, and we will arm you with the proper information to allow you to do just that. It's time we start doing things for ourselves and not relying upon the foxes
Who guard the hen house. That's correct.
Okay.
That is correct.
So, now, we move forward again. We move forward to the day after these arrests. And I received a little visit from the sheriff's deputies. I live in a neighboring county to Clayton, but driving up to my house was the sheriff's deputies for Clayton County, and they delivered to me a letter from the sheriff's department, which I will post up here for people to see. And it basically said, Mr. Swinson, you are not allowed to return to the Clayton County Courthouse, to the Clayton County Sheriff's Office, or to the Clayton County Board of Commissioners without first seeking approval to do so, and by giving 2 days' notice. I was given a number to call, and it also instructed me that when I was at the courthouse, I would have an escort the entire time I was there. Now, folks, and Paul, is that not yet another form of intimidation?
Let me explain that first off, that came from the interim, an individual who identified himself as the interim attorney for the board.
No. I'm talking about the one from the sheriff's department.
Oh, from the sheriff's department, excuse me.
Yeah.
Yes, the sheriff's department, yes, that's yes, that is a form of intimidation. And here is the sheriff's problem. Well, I can't say it's the sheriff's problem because, well, yeah, it's the sheriff's problem because he's in charge. The buck stops at his desk. But it was signed by a underling doing what he was told to do. And so that individual has a problem because what happened was that letter of intimidation was delivered across a county line, which means that that letter and the author, the letter is a criminal act or is evidence of a criminal act. The officer who signed it is the one who perpetrated the act, even though he was ordered by someone higher up. And he'll have to turn state's evidence. He's going to have to rat them out. That's all there is to it, to cover his fanny. Now, the nice thing about a grand jury, let me pause right here and tell you about the power of a grand jury. If a grand jury knows within reason that someone was ordered to commit a crime, then that grand jury can bring that individual in and tell them, listen, we know you didn't think of this on your own. You were told to do this by somebody. So here's your deal. We're going to give you immunity from prosecution. In this case, we're going to give you transactional immunity. And in exchange for that immunity, you're going to admit what you did, and which they call that allocuting, and you're going to tell us who ordered you to perform this act. Now, if you don't, then you could be looking at 5 years, because we will recommend in part of our indictment and our presentment attached to it that you be given the maximum charge if a jury finds you guilty. And so that individual will tell in a heartbeat, most likely, who ordered him or her to do the act that they did. And the pitiful part of it is, it started in Clayton County, it finished up in Henry County, which means a crime which crosses county borders can be tried in either county. Well, guess what? You're not going to be making a complaint in Clayton County. You're going to go to the Henry County District Attorney, Sheriff, Chief of Police, Grand Jury, preferably the Grand Jury, but tell the District Attorney why you're doing it is because of this letter of intimidation.
Does that not also apply to the letter you received?
Everybody is having a problem with Bartow County.
They're having a bad day.
They're having a bad day because they're not going to get tried in Clayton County. They're going to be brought up here to They're going to spend their time vacationing between Bartow and Henry County.
And it's about, I want to say, 90 to 95 miles, give or take.
Yeah.
So they really did step on it when they did this. Now, the first letter coming from the sheriff was only addressed to me.
Yeah. I'm jealous of you in that regard. You got the sheriff's attention. I didn't. I'm sorry.
2 days later, I get a call from, or I get a visit from the Clayton County Sheriff's one more time. Same people. And they were delivering me a message from the county attorney, Mr. Jack Hancock, who also was trying to do his own version of intimidation. And again, I will put this letter up so that you can look at it and review it yourself. But we now have the county attorney, the very same county attorney who was let go for this little $2 million mistake that he made back in 2011. Minor mistake. And besides, as Dennis Baker told me, recently I might add, and on tape, we determined it was okay because he put the money back. Okay, so folks, this is how the foxes guard the hen house. They present this to the grand jury. In this case, it was a special grand jury that doesn't even have the power to indict. But they do have the power to make a presentment to the regular grand jury so that they can indict. So if it doesn't get past the special grand jury, it's done.
The concept in the state of Georgia of a special grand jury is it's a smoke and mirrors. There, under Georgia law and under Georgia's Constitution, there is no special grand jury. I don't care what the legislators and the lawyers and the judges want you to believe. The Constitution provides there shall be one grand jury in each county. There can be several grand juries impaneled at one time.
Okay.
But each grand jury that is impaneled takes the same oath and exercises the same powers. And if they tell a grand jury who has been sworn that they don't have the power to issue an indictment, That's where you need knowledgeable, fully informed citizens who will take that individual and present them for trial for, well, actually, no, don't even present them. Just tell the Superior Court judge, put them in jail for contempt until they are ready to admit there is no such thing as a special grand jury without indictment powers. Now, that's what ought to happen. But there is no constitutional provision for the legislature to establish a special grand jury.
Well, this brings you up to the present day right now, and we have had a lot of banter back and forth in the news agencies, the newspapers, that seem to want to cover for these criminals, and they slant their reporting that way. Comments go back and forth, and one of the comments that seems to be really prevalent in the dialogues, in the dialogues that are on the newspaper's online website or in YouTube. So one of the most predominant things is that we're crazy.
Mm. Yeah, I'm extremely crazy about my rights, privileges, and immunities. And I take an extremely dim view. As a matter of fact, and let me just be, I'm going to be perfectly blunt. 25 years of being consciously aware of the corruption that's grown in this state. And I have reached the point now where any judge who is found guilty of violating their official oath of office or committing any criminal act that deprives a citizen of their rights should face a death penalty charge. They should be taken out at sunrise and executed. Stand them to the wall. I'll even volunteer to pull the trigger. And I'll go home and get me a dang good night's sleep. You know, that sounds cruel. I don't care. I have suffered the abuses of incompetent criminals who move around in the guise of public servants too long. It's time they started paying the price.
And that is where we're going to wrap up this third segment. Again, I want to thank you, Paul, for your wonderful input into this, your sage advice, and also the bullet points that you have provided in the law that you have cited. And this is where we're at, folks. We have inherent rights. We have the duty and responsibility to exercise those inherent rights. And only by virtue of the fact that we haven't, have they, the criminals in government, been allowed to do what they've done. So we will close with that, and there will be more to come. Thank you very much. Thank you, Paul.
You're welcome.